Hello everyone. The topic that we are going to cover today is important IPR related treaties and international agreements. As a pharma profession, we must be aware of some of the treaties that I am going to cover today. So be with me for another 5 to 10 minutes. Let us start with the presentation which going to cover important IPR related treaties and international agreements. The first question that comes into our mind, what is treaties? So treaties are international agreements between states or nations and our international organizations. Sometimes we call these treaties conventions, declarations, agreements, protocols, acquis, charters, final act, general act. A strong international protection of intellectual property rights is vital for future economic growth and development of all countries. International IPR treaties create common rules and regulations. Hence, they are vital to achieving the robust security of intellectual property that fuels global economic development and the growth of emerging technology. However, until the 1994 Uruguay round of the GATT created the WTO, that is nothing but World Trade Organization, and included the agreement on trade related aspects of intellectual property rights, that is nothing but TRIPS. The international community had no single source for intellectual property obligations and norms. Let us take a look into the history of treaties, how they come into existence. So here we have listed treaties and international agreements. In 1883, Paris Convention was signed for the protection of the industrial property. So that was signed in the Paris, France, headquartered in the Paris, to protect the industrial properties like patent, industrial design, trademarks, service marks, layout designs, geographical indications. This international agreement is the first major step taken to help creators ensure that their intellectual works are protected in other countries. Berneu Convention that was signed in 1886 for the protection of the literary and artistic work. The Berneu, which is in the Switzerland, and the main aim is to give creators the right to control and receive payment for their creative works on an international level. Work protected includes novels, short stories, poems, plays, songs, operas, musicals, and drawing, paintings, architecture works. Berne Convention work on three principles for national treatment, automation protection, and independence of protection. In 1891, Madrid system come into existence. Madrid is a city in Spain, and this agreement signed in Madrid city, so we call it is Madrid system, which is used for registration of trademark and governed by Madrid Agreement and Madrid Protocol. With the adoption of the Madrid Agreement, the first international IP filing service is launched. In 1925, Hague Agreement concerning the international registration of industrial design. The Hague system is an international registration system that enables owner to obtain protection for their industrial designs with a minimum of formalities and expenses. The Hague system had 42 contracting parties as of 26th April 2005. Bretton Woods system given birth to the GATT, that means General Agreements on Tariffs and Trade, in 1947. This GATT we are going to discuss in the next lecture in detail. So in 1958 we came up with the Lisbon Agreement for the protection of appellations of origins and their international registration. So what is the meaning of appellation of origin? Appellation of origin means geographical indication. Geographical indication means the something which is originated from the place and the name is given to that particular product based upon the name of the place. So that can be internationally registered. In 1961, the International Convention for Protection of New Varieties of the Plant. In this convention, the motivation was given to develop a new variety of plant that may be disease resistance, drought resistance, cold tolerance, or simple aesthetically more pleasing varieties of the plant. In the same year, in 1961, Rome Convention signed for the protection of performers, producer of phonograms and broadcasting organization. Performers like actors, singers, musicians, dancers, and those who perform literary and artistic work. If one person sings a song, other person like dancer, lyricist, musician are also covered under that act. In 1967, World Intellectual Property Organization comes into force by the dissolving the earlier BIRPI, that is nothing but the BIRPI, which was established in the 1893. By dissolving this, we come up with this particular WIPO. The newly established WIPO is a member-stated intergovernmental organization with its headquarters in Geneva, Switzerland. In 1970, we signed PCT, that is Patent Cooperation Treaty. The roots of the Patent Cooperation Treaty go back to 1966, when the Executive Committee of the Paris Convention for the Protection of the Intellectual Property called for a study of how to reduce for applicants and patent offices the duplication of efforts involved in the filing and obtaining patent application for the same invention in different countries. The resulting WIPO treaty, that is nothing but PCT, was signed in Washington DC in 1970 and entered into force in 1978. The PCT expands rapidly to become WIPO's largest international intellectual property filing system today. In 1977, Budapest Treaty on the international recognition of the deposit of microorganisms for the purpose of patent. The Budapest Treaty eliminated the need to deposit microorganisms in each country where patent protection is sought. Microorganism deposits will remain available for the life of the patent, and that samples will be furnished only to those persons or entities entitled to receive them. In 1994, WIPO Trademark Law Treaty that was signed. The TLT, which is nothing but Trademark Law Treaty, was enacted to simplify procedures in the application and registration process and to harmonize trademark procedures in the different countries. In 1995, WTO was established. The WTO is an intergovernmental organization that is concerned with the regulation of international trade between nations. The WTO official commenced on 1st January 1995 under the Marrakesh Agreement, signed by 123 nations on 15th April 1994, replacing the General Agreements on Tariff and Trade, which commenced in 1947. It is the largest international economic organization in the world. In the same year, 1995, TRIPS was signed. So that is nothing but Agreement on Trade-related Aspects of Intellectual Property Rights. TRIPS was negotiated at the end of Uruguay round of the General Agreements on Tariffs and Trade between 1989 and 1990 and is administered by WTO. The TRIPS agreement introduced intellectual property law into the multilateral trading system for the first time and remains the most comprehensive multilateral agreements on intellectual property to date. In 2000, WIPO signed a patent law treaty. The PLT is the product of several years of multilateral negotiation on harmonizing global patent system. In 2001, Doha Declaration on TRIPS and Public Health. The purpose of Doha Declaration was to recognize public health problems. We are going to see this in detail in our upcoming lecture videos. The Singapore Treaty on the Law of Trademarks was adopted in Singapore on 28 March 2006. It entered into force on 16th March 2009. The treaty establishes common standards for procedural aspects of trademark registration and license. Now we will see which above listed agreements comes under which organization. It goes to the WTO or WIPO. Under the WTO umbrella, we have GATT, GATS, 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 TRIPS, TRIMS, and AOA. Next, we have WIPO, which administers 26 treaties, including WIPO Convention, and which is divided into three groups. The first general group of treaties defines internationally agreed basic standards of intellectual property protection in each country. This group covers total 16 treaties. They are listed here. The second general group, known as the Global Protection System Treaties, ensures that one international registration or filing will have effect in any of the relevant signatory states. The services provided by WIPO under these treaties simplify and reduce the cost of making individual applications or filing in all the countries in which protection is sought for a given IP right. The next, that is third and final general group, is the classification treaties, which create classification systems that organize information concerning inventions, trademarks, and industrial design into indexed, manageable structures for easy retrieval. So, I hope that you are a little clear about treaties and international institutions. In the next lecture, we will be discussing about WTO and its agreement. This is going to be end of my presentation, and hope you enjoyed my presentation. Have a great day. If you have any question, ask me in the comment box.